You will recall from Chapter 4 that restraints on actions of government against individuals generally are referred to as civil liberties. In Chapter 5, we are going to talk about civil rights. Now, you recall that I mentioned that we typically use the term civil rights and civil liberties interchangeably. However, it's important to keep in mind the definition and the explanation of the terms as we are using them in the context of this course. By the time we finish Chapter 5, you will be able to summarize the historical experience of African Americans, state how the separate but equal doctrine was abolished, and describe the consequences of the civil rights movement. You will be able to contrast the goals of the women's suffrage movement with the goals of modern feminism. You will be able to explain the demographic impacts of immigration and the interactions between the European settlers and American Indians. You will be able to define affirmative action and provide arguments that are being made for and against affirmative action. And then finally, you will be able to summarize the recent revolution in the rights enjoyed by gay men and lesbians in the United States. So again, when we think of the term civil rights and civil liberties, restraints on the actions of government against individuals generally are referred to as civil liberties. So these are restraints on the government, not the individual. The term civil rights refers to the responsibilities of the government to provide equal protection and freedom from discrimination for all citizens. These are the things that the government must do. Civil liberties are the things that the government cannot do. So make sure you understand, make sure you remember that. Civil rights are things that the government must do. Civil liberties are restraints on the government, things the government cannot do. Civil rights are rooted in the 14th Amendment and its equal protection under the law. While most minorities have endured discrimination in this country, two movements, the Civil Rights Movement and the Women's Movement, have had significant social and political consequences, including sweeping legislation that has secured important rights for all citizens. Before 1863, the Constitution protected slavery. The inferior status of African Americans was confirmed in the Supreme Court's infamous Dred Scott decision. Recall, this is the decision in which the Supreme Court ruled that a black man, whether enslaved or free, had no rights that a white man was bound to respect. The Dred Scott decision, thought to have contributed to the outbreak of the Civil War. As a consequence of the Dred Scott decision, it became evident that for those who were opposed to slavery, they had now become complicit in slavery. Constitutional inequality ended with the Emancipation Proclamation and the passage of 3 amendments. Those 3 amendments are typically referred to as the Reconstruction Amendments, and if you have taken American history, you have learned a lot about those Reconstruction or post-Civil War amendments. These constitutional amendments are the 13th Amendment, the 14th Amendment, and the 15th Amendment. The 13th Amendment, which was passed in 1865, prohibits slavery within the United States. The 14th Amendment, passed in 1868, says that all persons born or naturalized in the United States are citizens, and this bans states from depriving a citizen of the privileges and immunities or depriving any person of due process and equal protection under the law. The 15th Amendment, which was passed in 1870, establishes the right of citizens to vote. To enforce those three amendments, Congress passed a series of civil rights laws. The first was the Civil Rights Act of 1866. It involved citizenship and further authorized the President to enforce the law of the National Armed Forces. The Enforcement Act of 1870 set out specific criminal sanctions for interfering with the right to vote. The Civil Rights Act of 1872 involved depriving individuals of the rights and privileges. And the Second Civil Rights Act, which was passed 3 years later in 1875, involved providing public accommodations. Now, this image is of an African American soldier in the Union Army during the Civil War. This picture was taken in about 1863. What influence might such troops have had on the struggle for African American rights during the Civil War? Remember, this is the first time in which African Americans were allowed to fight and were promised and granted actual equality for that. Remember, the ultimate cause and issue of the Civil War, of course, is slavery. Now, those Reconstruction statutes, or the Civil Rights Act, actually provided very little legal security for African Americans and were essentially nullified by subsequent legislation in various states. You'll recall from American history that many states enacted poll taxes and literacy tests. Many states enacted other barriers and allowed intimidation to go unchecked in the polls after 1876. The Supreme Court invalidated the Second Civil Rights Act with its widely approved ruling in the civil rights cases of 1883. In those cases, the Supreme Court held that the enforcement clause of the 14th Amendment was limited to correcting official actions of the state, meaning that discriminatory acts by private citizens were completely legal. And while never officially repealed, other civil rights laws were virtually ignored. Now, this distinction is very important because most businesses in the South, where we will see those battles for segregation be fought again in the 1960s, businesses were owned by private individuals, which meant they were not required to follow those portions of the law. Now, the Supreme Court went much further in 1896 in the very famous Plessy versus Ferguson ruling. And in this ruling, the court held that the 14th Amendment did not intend to abolish distinctions based on color, and that segregation alone was not unconstitutional. This established the separate but equal doctrine, which originally authorized the segregation of railway cars, but quickly expanded to all forms of public accommodations, including hospitals and schools. It supported the South's state and local Jim Crow laws, establishing all types of separate public facilities based on race. When white supremacist politicians regained control of Southern state governments after Reconstruction ended, they enacted laws that virtually prohibited African Americans from voting. The white primary restricted voting in primaries to whites only. The grandfather clause restricted voting to those whose grandfathers had voted before 1867. Now, this grandfather clause is very important because many white Southerners were very poor and destitute. They could not pass a literacy test and they did not own land. However, in order to ensure that they were able to vote, this grandfather clause put into place a restriction on anyone whose grandfather would not have been able to vote prior to 1867, which essentially made it impossible for any African American to vote. Of course, poll taxes and literacy tests were also implemented, and literacy tests were arbitrary and required recitation skills and reading skills that were judged by the person who gave that test. Southern social customs and codes of behavior maintained the inferior status for African Americans. Examples of this are familiarity, which was a serious violation, meaning that African Americans could not be too close physically to anyone who was white. Lynching was also used and was rarely prosecuted as a mob murder. Now, separate but equal is the doctrine that governs much of life in the United States, not just the South. By the 1930s, the courts had begun to erode this controversial ruling, and by the 1950s, the court explicitly overturned this case. The 1954 decision in Brown v. Board of Education of Topeka, Kansas, the court ruled that segregation by race in public schools violated the 14th Amendment, stating that separation implied inferiority. This was the exact opposite of the decision from the Plessy ruling. Now, when this court decision was handed down by Chief Justice Warren, he said that schools separated on the basis of race were inherently unequal. And by this, what he meant was that if a school is separated by race, even if you provide the exact same physical accommodations, the exact same building, books, supplies, everything, it would still be unequal because it would be separated solely based on race. Now, over the course of the next year, after the Brown decision and the second Brown decision, the court ordered states to admit African Americans to schools in a non-discriminatory way, but with all deliberate speed. Now, with all deliberate speed is an interesting caveat, and there's no evidence to indicate that Chief Justice Warren intended it to be a new barrier to integration. But many Southerners responded to the Brown decision and this all deliberate speed clause by saying that there needed to be adequate time, adequate research to decide how best to integrate schools. And this was really just a stalling tactic. Some states challenged the court's ruling and attempted to block integration, resulting in riots, violence, and the federalizing of the National Guard. In Central High School in Little Rock, Arkansas, and the University of Mississippi in Oxford were two very famous cases. Now, as integration is starting to become more prevalent. What we see is that reactions are varied. Some take a militant reaction and begin to violently attempt to circumvent integration, and others take a more passive approach where they try to fund congressmen and representatives and mayors and so on, governors, to ensure that this law is never carried out. A question to think about is when Oliver Brown wanted his daughter Linda to attend a white school that was close to their home, he took the case all the way to the Supreme Court. Your question is, the outcome of the case is considered a landmark decision. Now, it's important to understand that part of the objective of Oliver Brown here was that there wasn't a black school that was close to his neighborhood. So his young child had to ride a bus completely across town to a black school. And again, this was a situation of the county not providing an equal, separate school, which helped to strengthen this case. Geography and residence can complicate attempts to balance racial segregation in schools. This is called de facto segregation, or segregation that is due to patterns of residence and social conditions. Now, this is different from de jure segregation, which is segregation that is related to laws or policies of the public agencies. A solution to both forms of segregation seemed to involve transporting students across counties and to new schools. Courts began ordering busing, sending black students to predominantly white schools and vice versa. This led to significant violence in northern areas by the mid-1970s. Now, it is important, again, to remind ourselves that these segregation customs and laws don't just exist in southern states where slavery had been. That de jure segregation and de facto segregation also exists in the North. People tend to attend the school that is most close to their home. Most African Americans, as you will recall from American history, were prohibited from purchasing homes in white neighborhoods, which means they would not have been close to a white school. By the mid-1990s, the court backed away from its earlier commitments to desegregation, as did the lower courts. In 2001, a federal appellate court held that the North Carolina School District, Charlotte-Mecklenburg, had done enough to desegregate and would no longer be held to the constitutionally imposed initiatives. Many schools experience de facto segregation today, and this is largely due to high minority populations in urban areas. Many Americans are focusing on improving the performance of all schools rather than making them racially balanced. Now, beyond the public schools, segregation still existed in the 1950s. The elimination of the segregationist policies and racial intolerance would not have occurred without a strong civil rights movement. In 1955, Rosa Parks refused to move to the rear of the bus in Montgomery, Alabama. This sparked boycotts headed by Baptist minister Martin Luther King Jr., and giving birth to the era of civil rights protests. Now, Dr. King formed the Southern Christian Leadership Conference in 1957, advocating a philosophy of civil disobedience, or nonviolent public refusals to obey allegedly unjust laws. He and his followers successfully used peaceful demonstration and marches to gain widespread public acceptance. The violent reactions to protesters only strengthened the public's support for the civil rights movement. In 1963, civil rights leader A. Philip Randolph and Bayard Rustin organized the March on Washington for Jobs and Freedom. Massive crowds and millions of TV viewers heard Martin Luther King Jr. deliver his now famous "I Have a Dream" speech. You're probably familiar with the speech, but this speech was given at a March on Washington for Jobs and Freedom. Here you can see Dr. King giving this speech. Martin Luther King Jr.'s speech at the Washington Monument in 1963 was watched by millions of Americans. His most famous words were, of course, "I have a dream." His dream was that one day children would be able to go to school together, that they would be integrated together, and that they would be judged by the content of their character and not the color of their skin. The March on Washington, plus compelling media coverage of violent attacks on demonstrators, led Congress to action, creating a second era of civil rights called the Second Reconstruction Period. As the most far-reaching bill of its kind, the Civil Rights Act of 1964 prohibited discrimination based on race, color, religion, gender, or national origin. It specifically covered voter registration, public accommodations, public schools, employment, and funding cuts for violations. It also created the Equal Employment Opportunity Commission to deal with workplace inequalities. The next year, we see the Voting Rights Act of 1965. In 1960, less than 30% of eligible African Americans in southern states were registered to vote, but far fewer actually did vote. The Voting Rights Act of 1965 addressed the issue with two provisions. One, it outlawed voter registration tests, and two, it authorized federal officials to take over the registrations and polls if discrimination was detected. One area not yet addressed was housing. The Civil Rights Act of 1968 prohibited discrimination in most housing and set penalties for violations. Later, legislation banned discriminatory mortgage and lending practices. Now, you might recall from American history that mortgage and lender companies would only lend to African Americans and approve that loan if they were purchasing a home in areas that were designated as available for African Americans to purchase. Even if they had the money to secure a home, they would not be sold a home in a white neighborhood. And so this Civil Rights Act of 1968 specifically addresses this. The Voting Rights Act and related initiatives led to a dramatic increase in voter registration rates of African Americans. This number increased to more than 55% in the South by 1980. An unprecedented turnout was seen in the 2008 presidential election when the nation's first African American candidate was on the ballot. Today, more than 10,000 African Americans hold elected office, including more than 40 members of Congress. It appears that race may not be a significant factor in the minds of the voting public as it once had been. Comparing Gallup poll data from 1958 and 2008 indicates an overwhelming increase in respondents' willingness to vote for an African American president. Civil rights legislation has ultimately benefited almost all minority groups. Hispanics have gained political power and increased their number of elected officials at all levels of government, including 27 members of Congress. Asian American representatives have remained stable at more than 13 members. Women have had a long struggle for equality, beginning with obtaining suffrage, or the right to vote. Activism for women's rights began at the Seneca Falls Convention in 1848, organized by Lucretia Mott and Elizabeth Cady Stanton. Two major groups were established in later decades. One, led by Stanton and Susan B. Anthony, focused on widespread economic and social gains. Another, led by Lucy Stone, focused only on the right to vote. The two groups merged in 1880 to form the National American Woman Suffrage Association. Along with Alice Paul's more militant Congressional Union, the push for women to vote continued. The 19th Amendment was finally passed in 1920. This amendment stated that the right of citizens to vote would not be denied or abridged on account of sex. The granting of suffrage in the United States took time, but it compares to the efforts to grant access to the ballot to women in other states. The term feminism was first used around 1910, but there was little public support for such a radical notion. After gaining the right to vote, women's political activity died down until the 1960s. The modern women's movement grew out of the civil rights movement and an awareness of rights for all groups. The publication of Betty Friedan's The Feminine Mystique in 1963 and the formation of the National Organization for Women, called NOW, and the growth of the women's liberation movement fueled the fires of feminist movements. The initial goal of the modern women's movement was the ratification of the Equal Rights Amendment, which was first introduced to Congress in 1923, and said equality of rights under the law cannot be denied or abridged on account of sex. It was sent to the legislatures for ratification in 1972, but failed to get the necessary 38 states to approve it within the specified 7-year period. The women's rights movement turned to challenging inequalities through laws and court rulings, arguing that gender discrimination, meaning statutes, policies, or practices that denied equal treatment to individuals or groups based on gender, violated the 14th Amendment. Examples are Supreme Court's rulings banning police and fire departments requirements, as well as insurance company rates based on gender. It has never ruled on women in the military in terms of combat, but has left that to Congress and the Defense Department. Over the past 10 years, we have seen several opportunities for advancements for women in forward positions and positions in the military that have historically been reserved for men. Here we see a female soldier who is a medic and assigned to a medevac helicopter in Afghanistan. Medevac pilots, crew, and medics are ready to fly at a moment's notice, picking up a coalition soldiers as well as Afghans who require help. Under the Defense Department ruling, women in the U.S. Armed Forces can now compete to join in units that engage in direct combat. Now, this is a recent ruling, but it has changed the landscape of the military. Is this ruling a positive development for the United States? That's a question for you to think about. More women are serving in Congress than ever before, and women have made strides in the upper echelons of government. Examples being Geraldine Ferraro as a vice presidential nominee in 1984, Nancy Pelosi as Speaker of the House in 2006, Hillary Clinton as a near nominee in 2008, and an actual presidential nominee in 2016. More women are being appointed to cabinet posts and judicial positions as well. There are even women on the Supreme Court. Since the 1960s, women have made substantial gains in employment opportunity and equal pay. Title VII of the 1964 Civil Rights Act prohibits gender discrimination in employment and has been used to protect women from workplace discrimination. In 1978, it was amended to ban discrimination based on pregnancy. Title VII also prohibits sexual harassment, favoring employees in exchange for sexual favors, or subjecting employees to inappropriate conduct or comments called a hostile environment harassment. During World War II, the Labor Board evaluated jobs and set an equal pay for women policy. That ended when the war ended. In 1963, the Equal Pay Act banned employers from setting separate pay scales for men and women who were doing the same work. But it did not mention paying less for jobs that were traditionally held by women. In 2009, the Lilly Ledbetter Fair Pay Restoration Act extended the period for which women can sue under the Equal Pay Act. While historically, most immigrants came from Europe, today most come from Latin America and Asia. The U.S. Census Bureau says Hispanic individuals can be of any race and can be new immigrants or long-term residents and can come from about 20 countries, most notably or commonly Mexico, Puerto Rico, and Cuba. Most Hispanic Americans prefer the term Latino or Latina as opposed to the term Hispanic. The U.S. composition is changing due to immigration as well as ethnic differences in fertility rates, or the average number of children a group will have that a woman in a particular group will have in her lifetime. Hispanic Americans have the highest birth rates. We've seen significant declines in the birth rates of women of European descent. Latinos are usually considered a minority needing protection from discrimination. Immigrants who are not yet citizens have the fewest civil rights of any legitimate group in the United States. But those who are authorized immigrants, also called illegal aliens and undocumented workers, have fewer still. Despite the law banning discrimination of minority groups in 1964, Some groups and women commonly lack skills and training to compete in the marketplace. Some of those groups were Native Americans. Now, you might think that Native American men would have been given the right to vote under the 15th Amendment. And yes, in theory, they should have been. However, Indians were not considered citizens at this time. The Native Americans were separated from the law because they were restricted and relegated to reservations. So when women were granted the right to vote, Native American women were not granted the right to vote. As time moved on, Native Americans, still relegated to reservations, had no voice in Congress. Now, in 1924, Native people won the right to full citizenship. They were granted citizenship. However, because they lived on reservations, they most often weren't able to vote, as there was no polling place in that area. Additionally, individual states decided where and how people were able to vote. This will be the case through the Voting Rights Act of 1965, which ultimately helped to strengthen the rights of Native Americans to vote. The Supreme Court ruled in 2013 in Shelby County versus Holder that states with historical racial bias in voting needed to get permission before they made any new laws. As a result, this made it easier for African Americans and Native Americans to access the ballot. Here we have Russell Means, who is a member of the Oglala Sioux tribe and a former head of the American Indian movement. Here he is testifying before a Senate committee. Now, he died in 2012 at his ranch in South Dakota. He was 72. The struggle for American Indian rights has been popular among Americans. Why might that be so? Now, it's also important to understand that Native Americans are still connected to this reservation legacy today. So that also impacts their historical access to the ballot. Now, I mentioned the percentages in changes of ethnic distribution. If we look here at 2000, this would have been right when I was graduating high school, about 70% of the population was in this blue category, this white category, and so on. The smallest area in this category here being Hispanic, or not Hispanic, I'm sorry, being other. As we inch on to 2010, looking to 2020 in a few years, we're seeing this number here of the white population declining. We are seeing the increase in Hispanic population significantly, more than doubling. We're also seeing significant increases across all other areas. Despite the law banning discrimination in 1964, many groups, as well as women, have historically lacked skills and training to compete in the marketplace. So affirmative action policies were established to level the playing field and to give favorable treatment in school admissions and hiring processes so that groups that had suffered discrimination could increase their abilities to be hired or admitted into school. These policies expanded the interpretation of the 14th Amendment's Equal Protection Clause. In 1965, by executive order, President Johnson authorized affirmative action programs and requiring compliance from all state and local agencies, all companies that sold goods and services to the federal government, all organizations that received any form of federal funding, such as schools, and employees or labor unions that were found to have had a history of discrimination. Now, controversies have involved possible discrimination against majority groups or others that are not specifically identified in the programs. Affirmative action was first brought before the Supreme Court when a white man claimed that he was not admitted to the medical school in California due to reverse discrimination. In the case Regents of the University of California v. Bach, which was handed down in 1978. The court ruled that a quota system based solely on the race of the applicant was unconstitutional. This means that it is unconstitutional for an organization to decide that they need to have a certain number of employees from various demographics. In 1995, the court ruled in Arand Constructors Incorporated v. Pena that affirmative action programs must operate under strict scrutiny and meet a compelling government interest. They could not favor an unqualified person, and they had to be discontinued once the goal was met. In two 2003 cases, the court indicated that race could be a part of the full evaluation and that diversity was a legitimate goal in college admissions, but it prohibited automatically assigning points based on minority status. So this means that a person cannot be hired for a job because they are a minority, but it also means that they cannot be excluded because of their minority status as well. Several states have banned all state-sponsored affirmative action programs, though some voters, as in Colorado, have rejected those bans. In a 2007 case regarding voluntary state school integration plans that used race as a deciding factor for admission, the court ruled that that violated the Equal Protection Clause. Will affirmative action end? Should affirmative action end? Well, that's something that you want to start thinking about. Remember, affirmative action doesn't say that you can hire a person or admit a student who isn't qualified based on their race, but it goes further to say that they cannot be excluded because of their race. But what do you do when you have one position to fill or one admittance and you have two equally qualified candidates and one is black and one is white, or one is black and one is Hispanic? How do you decide who is hired when the credentials are the same? It's a tough decision. In 1969, riots erupted in response to police raids of a popular New York bar that was frequented by gay men and lesbians, called the Stonewall Inn. Many who had historically avoided activism due to the stigma attached with homosexuality now joined in what was called the Gay Power movement, and the Gay Liberation Front and the Gay Activist Alliance was formed. The gay rights movement has expanded into thousands of organizations working for the right and equal treatment in all areas of society. These groups have largely succeeded in changing public opinion, but age-old bias and divisive issues do remain. Targeting gay men and lesbians by state and local laws was commonplace in the 1960s. In the 1960s, every state except for Illinois had sodomy laws, which banned various sexual activities, including homosexual practices. After Stonewall Inn, many states repealed those laws. But in Bowers v. Hardwick in 1986, the Supreme Court upheld a Georgia law banning homosexual conduct between adults. Then, in Lawrence v. Texas, the court reversed itself and ruled that such laws violate the Due Process Clause of the 14th Amendment, thereby striking down all remaining sodomy laws as a violation of due process. Today, more than 25 states and numerous cities and counties have anti-discrimination laws protecting gay men and lesbians. Some have attempted to ban those laws, but in 1996, the court stated in Romer v. Evans that such laws violated the Equal Protection Clause by denying homosexuals the protection under the law. President Clinton instituted Don't Ask, Don't Tell, a policy to protect gays against discrimination from the military, a compromise short of his promise to repeal the military's long-term ban on homosexuals. President Obama also promised to repeal this bill, or this law, but Congress failed to enact legislation throughout the beginning of Obama's administration. Congress finally passed a gradual repeal that phased out the policy by the end of 2011. The most pressing political debate in the realm has been whether or not gay and lesbian couples could be allowed to marry. In 1993, the Hawaii Supreme Court ruled that the state constitution protected the right of same-sex individuals to obtain marriage licenses. Congress responded by passing the Defense of Marriage Act in 1996, which banned any federal recognition of same-sex couples and allowed states to ignore marriages performed in other states. Now, this meant that if a same-sex couple had been married in Hawaii but lived in North Carolina, that North Carolina did not have to recognize their marriage and that they would not be able to qualify for benefits that regular traditional married couples would have. In 1999, the Vermont Supreme Court ruled that gay couples are entitled to the same benefits of marriage as opposite-sex couples. So, its legislature legalized what they called civil unions that allowed for hundreds of state benefits, but no federal benefits like Social Security. By 2011, 12 states had enacted similar policies. In 2003, Massachusetts was the first state to recognize gay marriage, ruling that civil unions were not sufficient. Other states that quickly followed suit were Connecticut, Iowa, New Hampshire, and Vermont, as well as the District of Columbia. New York and Maryland recognized such marriages from other states. California and Maine used a voter referendum to overturn the newly enacted gay marriage laws. But in 2010, a federal judge ruled that citizens could not ban same-sex marriage by amending the state's constitution. That issue went to the Supreme Court. North Carolina also enacted a referendum in which the voters voted at about 60% to add an amendment to the state's constitution that defined marriage as a union between one man and one woman. All of those individual states that had enacted those types of laws found those laws overturned by the Supreme Court. This same-sex couple in California was married during a several-month interval in 2008, when such marriages were legal in the state. California continued to recognize these marriages even after a vote in November of 2008, which prohibited the new same-sex marriages. Why has support for same-sex marriage grown in the United States? Is it fundamentally unfair for same-sex couples to experience economic disadvantages in some states? Or do you think marriage should be regulated at the state level? Was the Defense of Marriage Act unconstitutional? Why or why not? Think about what you have learned, think about what you have read, and be prepared to answer those questions. Thanks.